welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And today we're back in Calloway County with injury attorney Jeff Roberts. Jeff, how are you again?
I'm doing good, Jim. How are you?
Buddy, I'm doing well. Always good to sit down and talk with you for a little while. It's been a while since we covered this topic, but today we're going to jump into something called premises liability. And then we're going to talk about on the commercial side and also on the home residential side, because there are two aspects of this. Would you do this for the audience? Let's just kind of clarify, what is a premises liability claim?
Premises liability claim is a claim against basically a property owner for an injury that occurs on someone else's property. So on the premises of someone else, and you get injured because of negligence on their part, then they can be responsible for your damages, your lost wages, your medical bills, any pain and suffering, things like that. So you get essentially the same kind of damages you would get in a car wreck. Car wreck, you have to have negligence on the other driver. In this, you have to have negligence on the part of the property owner or the one who leases the property, because the building may be owned by one person but leased by somebody else type situation. So it can be different settings, but it's on either residential or commercial property as a general rule is what you're looking at.
Okay, so is there any limit in the severity of the injury, or can it be really anything? I mean, and we're going to talk on the commercial side, the first thing obviously is a slip and fall. So if I fall, a substance usually, like I think we talked about milk or soap or something like that in an aisle in a shopping center, in a grocery store.
Correct. That's usually, you see a lot of premises liability cases that are classified as quote unquote a slip and fall type case, where someone slips on a slippery substance in the floor. It can be a liquid in the floor. I've seen several times where some stores will have the bags of ice inside the store. Well, people reach in and get the bags of ice, and then you've got the frost that falls off. And now, because of the liability associated with that, you see a lot of times they got rugs right there in front of that to catch that aspect of it. But for a long time they did not have, and some probably still don't have, and that gets on the floor, and then somebody comes along and it's clear liquid on the floor. You don't see it as you're walking, and then they hit it and slip and fall. And it can be anything from a sprained ankle to a severe head injury if they fall back, because a lot of times the floors in these places are concrete slab with tile or something like that over the top of it. So if you fall hard enough going backwards, you can cause a severe concussion or severe closed head trauma from that can have lifelong consequences. So it can be a minor sprain type injury to a severe injury that people can suffer from those things. But it doesn't have to be a liquid substance on the floor. So it could be, if someone drops some kind of paper that would be slick. Thing that comes to my mind that is slick if it's on the floor is like a dryer sheet. If that gets on the floor, that can be very slick. Now, why one would be out in the store or get on the floor is a different question. But
you see open packages, in stores all the time.
Exactly, like that, or it could be a piece of plastic on the floor that you hit, and then it causes you to fall, slip and fall. But that's what you're looking at from that standpoint there. And a lot of times that is what you see in where someone falls. Some sort of a liquid. It's a soap on the counter or on the shelf. One of them gets busted open and it spills out onto the floor, or a milk's got a little pinhole in it that you don't realize, and frankly somebody could put it in the cart and not realize it's leaking, and then it leak in several different spots inside that floor. inside the store in that situation. So there's a lot of things that can cause the substance to be on the floor, and that's part of the issue in these cases is what was on the floor, if anything, that caused the person to fall. How long had it been on the floor? How did it come to be on the floor? And those all come into play in determining negligence in whether the property owner, the business, is liable. If like the situation where it's the ice and they're getting in and frequently they get water on the floor, the company, the business knows about that, does not take steps to protect that, then they're going to be negligent, even if it had just gotten on there because it's a repeated hazard and they hadn't taken steps.
They should have anticipated that was going to happen.
Exactly.
Okay.
If it is a small kid in the soap aisle who opens up one and pours some on the floor, and mom or dad catches him and picks him up and gets him in the cart or whatever and goes on, and the next person that comes along 3 seconds, 5 seconds later hits it and falls, well, the store didn't have the opportunity to discover and clean that up, so there may not be any liability in that setting from that situation. So those all come into play in determining what fault lies with the store owner in this. If the kid spills it and it sits there for 15, 20 minutes, you got store personnel walking up and down the aisle, and they don't notice it, or they look at it and don't clean it up, or don't take steps to notify others to get it cleaned up, then there's clear negligence in that setting, and they're going to be liable for the injuries caused from that standpoint. Now, that doesn't take away comparative fault that we've talked about before, so it could be that the person who slips and falls may have a little bit of liability themselves for not. And I guarantee the insurance company and the business owner are going to argue they have liability for not looking where they were going and watching from that standpoint. Now, what they don't tell you is they spend a whole lot of money to draw your attention to the shelves to buy their product instead of looking at the floor.
Right. It's interesting you said that because in different episodes we've talked about pure comparative fault. In fact, in episode 96, we did a full episode on what is that in Kentucky law, what is pure comparative fault, and what's it, how can that affect your case and your settlement. But that was always in the context of a car wreck or maybe even a workplace accident. I never really thought of it in the situation where it's premises liability. You probably should have walked around that maybe.
Yeah, that's what's going to be the argument. Now, just to clarify, in workers' comp, comparative fault doesn't come into play. It comes into play if you're injured on the job by the negligence of someone else. But if it's you're on the job and you lift something very heavy and you hurt your back, they cannot say you're partly at fault for lifting that heavy object. But in the premises liability context, then they can always point to the at fault or to the injured party and say, you should have done X, Y, Z, and you're partly at fault or solely at fault for this. And, I've seen frequently where they kind of try to claim, well, they should have been watching where they were going. And that resonates with people when you first think about it. Yeah, I mean, you're responsible for where you walk, and you should be watching where you're going. When you talk about I'm here to look at these shelves and get these items off the shelf. Number one. Number two, you give me this big, huge cart that I'm putting my stuff in, and now I can't see
what's in front of me
for quite a while because of the stuff in my cart keeping me from seeing the floor. So it's they will make that argument. It shouldn't fly that far with the jury if you know what you're doing and explaining these things to the jury from that standpoint. But they're going to certainly make that argument
Absolutely.
when it's a slip and fall situation, and you still see the same argument on the. And it's hard to understand to some extent that there's actually a difference between slip and fall and trip and fall. Trip and fall is, when I talk about that, at least what I'm referring to is not something on the floor that's slippery that causes you to fall, but something protruding into the walkway. So, for instance, at Lowe's, if you're walking down the aisle at Lowe's and they've got a 2x4 that is, instead of running inside the aisle, like inside the shelving like it's supposed to, it's protruding 2 foot out into the walkway, and you trip over that. That's kind of what I'm talking about. Something
Well, that could also be a box or an item left
exactly.
in there, right?
It could be a box or item protruding out into the walkway. It doesn't have to be something off the floor. It could be on the floor, but it's protruding out into what is the designated walking area. From that, and frankly, sometimes it's a cord.
Yeah.
They put stretch a cord across somewhere that you're not expecting it to be, and then it's across a walk area, and somebody gets their feet trapped up in it, and they trip and fall from that standpoint. Still, the same situation comes into play where they're going to point and say, "Well, if you were watching what you were doing," type thing, then, and frankly, I think it's probably a little better argument for them in regard to something protruding into the walkway from that than it is with the slippery substance on the floor. But that is something that you're going to have to deal with. But even under pure comparative, if you're 10% at fault in causing this, or 50% at fault, they're responsible for 50%. If they're 50% at fault, they're responsible for 50% of your damages. If they're 90%, they're responsible for 90% of your damages. That's the benefit of pure comparative fault. The at fault party only has to pay what percentage of fault they were to causing the injury. So
Yeah, interesting. Now, the other issue that comes out, and is related to items being in the aisle, it's items literally falling off of the shelf, and that could be in a Home Depot or a Lowe's or a Walmart or something, or even in just a grocery store.
Correct.
When an item just gets pushed over, or maybe wasn't loaded up properly, and it falls over, strikes somebody on the arm, on the head, on the shoulder, whatever, it can also be damaging.
yes, falling merchandise, and those can be very, very serious injuries. And if I've said before on this and to other people that some people complain about civil lawsuits. This is a prime example of how civil lawsuits protect society in some regards, and people may dislike it, but if your family's one that's protected by this, then you shouldn't dislike these. But at Lowe's now, if they are loading something in one aisle on the top shelf or even lower with the forklift, they block off that aisle where the forklift is. That's the way they used to do it. They blocked off the aisle where the forklift was. They used to not block off the other aisle on the other side where the forklift is putting stuff on the shelf. And what was occurring was in stores that did that was the forklift would hit the shelf, something on the other side would fall and land on the customer and cause injury. I've represented clients that that's happened to in that regard. Now what you'll see, hopefully, in these stores is if they're using a forklift to load something in one aisle on the shelf, they've got that other aisle blocked off as well, so you can't get down there. So if they do bump it, which happens frequently,
all the time,
and it knocks an item off on the other side, there's not anybody over there that's going to get hurt. I've had clients that have had serious injuries, totally disabling injuries from having product fall off and hit them in the head, and so it caused severe injuries to their neck that required multiple surgeries.
Wow.
And so that is, and I'm not saying my pursuing those suits are what caused the stores to change that, but the number of those suits occurring, and then them figuring out, hey, part of the lawsuits, in these lawsuits, is saying all you had to do was block this other aisle off, and this wouldn't have occurred. When they said, well, we didn't know this was going to happen. It's happened a ton of times in the past. You've not taken steps, and there's an easy step you could take to prevent it. You block off not only the aisle you're in, but you block off the other aisle.
Doesn't take that long to do, and you're not going to be loading stuff in and out during normal business hours for all that long of a duration of time.
Exactly. And so that is, that is just one small example. There's a lot of the examples where the civil justice system have made our country much safer than what it would be without the civil justice system. You would hope that companies would take these steps to make their stores safer for their customers without worrying about liability, but unfortunately, potentially having to pay out money is a bigger motivator than safety at times.
Yeah. Well, that makes sense. Well, let's talk about this, and we'll use this kind of as a transition topic going over to the residential. But in commercial situations, there are a lot of common areas. So if I'm in an apartment complex, I've probably got a common, like a swimming area or a stairwell or a laundry room, things like that. Common area accidents also happen, correct?
Correct. In an injury in the common area of an apartment complex, you could be a resident at the apartment complex or a visitor to the apartment complex. If you're injured in the common area, then the claim would be against the owner of the complex, not their tenant, but the owner of the complex.
That makes sense.
It's a common area. It's one they're in control of,
So if I'm
not the tenant.
If I'm visiting my buddy in his apartment and I fall in his apartment, he's responsible. The apartment owner would not be. But if I'm tripping in the stairwell or something else happens in the common area, that's their liability.
As a general rule, yes.
Yeah.
And that's so in like if there is slippery substance there, frequently a lot of times you will see in these common areas you'll have where there's a stairway and the lights have been out for a long period of time, and somebody shows up and they're not familiar with it, and they're going up and they miss a step because of the way the lighting, etc., is in there, and they fall and get hurt, and that's all on the property owner, not the tenants,
Right.
because the tenants aren't in control of replacing the light bulbs and maintaining the common area.
Yeah, it's a maintenance issue.
Exactly, it's a maintenance issue from that, and the reason I said earlier as a general rule, when it's a tenant situation, if they've got there are certain things even in a tenant situation, I think liability can come back on the property owner, like if they've got a back deck off of that is exclusively theirs, off of theirs, but that deck is in disrepair. It's rotten or something, and the tenant may have only leased it for a month and it's been rotten for a long time and the landowner hadn't done it. I think that could be potentially liability on both in that setting. But generally, if you're inside the apartment and there's something spilled on the floor that you slip on or whatever inside the apartment, or frankly, it could be a dog in there that bites you, that comes under premises liability. We a lot of times refer to those as dog bite cases, but comes under the premises liability standard from that standpoint as far as the type of claim you're filing anyway. So that's a claim against the property owner. If it's an individual home, and where you see that a lot is, people have a hole in their yard. They know it. They mow the yard. They know the hole is there in the yard, but guests on the property can't see it because the grass covers it, and the grass is the same height all over where you mow. So until you step in it, you don't know there's a hole, and the owner of the property doesn't warn the person that they've invited onto their property about that hole in the yard, or if they know, if it's going up to where their electric meter is to be read, and they don't let the people know or do something there, then they could be liable for just people who are on their property doing their business or delivering packages or something of that nature. That comes under the premises liability standpoint as well, where they could be liable for any injuries caused on the property, and that's the reason you have homeowners insurance, or should have homeowners insurance.
Absolutely. So as we're looking at that would explain a fall in the yard or something like that.
Correct.
But even if I have a back deck at my own residence, let's say I've got a backyard and I've got a deck and a railing, and that railing gives way during, let's say I've got a dinner party or something like that, and people are out there on the back deck, and the railing gives way. I mean, again, that is potentially a premises liability. There's not the property owner is that the person who owns that house at that point.
Absolutely, that is a premises liability claim. I've actually handled those type of claims as well, and amazing how many different types of claims you've handled over 33 years. But yes, those are clearly premises liability claims as well. If the deck is in disrepair in any form or fashion, if it's a deck board and you fall through and get injured, if it's a railing and you lean up against that railing and it's not proper and it falls over and you fall off, then it's there's negligence on the homeowner, and the homeowner's insurance would kick in and pay in that regard.
Let me ask you this: when we were talking about like in Lowe's or something like that, and there's a liquid on the floor, the management or the maintenance crew or whatever needed to have time to go to clean it up. They needed to be aware of it and clean it up.
That goes into play on whether they're negligent or how negligent they were.
So if I'm at somebody's house and the railing gives way, and as the owner, I didn't know there was a problem, or you step through the deck board, I didn't know it was rotting. Do I have any way of getting out of some of that liability?
Well, potentially, but it's going to, if it is to the point that it's rotted to where you fall through it, then you're going to have a hard time saying, I didn't know that was soft.
That doesn't happen overnight.
Yeah, that doesn't happen overnight, so it's a maintenance issue. It's a dangerous condition you knew or should have known about. So it's not just you have actual knowledge, but you should have known.
Okay.
So it's existed for a long enough time that you should have discovered that dangerous condition, that was in disrepair and needed to be fixed. So
hole
they still
in the
have
yard.
that
You should have known there was a hole in the yard. You had people over. You should have maybe blocked it off a little bit, or put a marker. Or something.
Fill it in, or put something over it to block it around to where people can't step in it. And that is situations that some things are just common sense.
Yeah. The one quality most lacking in the world.
True, and this going back to my way younger days, before law school, even when I was in college, and I had a friend that had a mobile home, and he had a hole in the floor. It was an older home. He was actually renting the place, but there was a hole in the floor, it hadn't been repaired, and instead of marking it, doing something to let people know, he was afraid something was going to, sorry about that. I talk with my hands and sometimes I hit the mic. I apologize. But he was afraid a mouse or something was going to come up through the floor. So he took a rug and laid a rug over the top of it, and nobody knew there was a hole in the floor to start with until one of our friends stepped on the rug and fell. So don't put a rug over it without telling people. If you got a hole in the yard, you got a hole in the floor, don't just barely cover it up, throw leaves over the top of it or something of that nature. You got to make sure that you do something to let people know this is a dangerous area. And if you warn of it, you're fine. I mean, frankly, that satisfies your responsibility. You're not negligent. If you mark it and say, with a cone and tape around it or whatever it is, block it off, and then somebody walks into it anyway, you're not. You've done your obligation. You have to either repair or warn of the dangerous condition. So. You probably recall when you first started coming to my office, you go into my bathroom, there was about a 4-inch step up going into the bathroom. I've got signs on the door that say, watch your step. But anytime somebody asks me, do you have where's your bathroom at? I will tell them where it's at. And I say, there's a little step up. Be careful going in. Every time, because my obligation is to warn of that condition.
I thought you were just being nice.
Yeah, well, I was being nice. I don't want to say you get hurt from that standpoint. That's the reason I'm doing that. I also don't want the liability from it either, but I warn everybody, watch that little step there, because you may not be expecting it. It's on both sides of the door. If the door is open, you see it walking to it. If the door is closed, you see it before you open up the door. But I also tell people for that very reason. That's it's my legal obligation. I think it's my moral obligation, if I know something's there, to warn people before they experience it so that they don't get hurt.
Well, let me ask you this, and how this would apply. Is there, I've heard of something called open and obvious as kind of a defense. What is that, and how does that play into these cases?
Open and obvious is, it's, the law on that has changed over time. In fact, I've been involved. I wrote an amicus brief on behalf of the Kentucky Justice Association several years ago that helped change that law or start
It's
the
kind of a
process of changing.
friend of the court brief,
Friend of
right?
the court brief, to help start changing that process. But what you used to hear frequently, like snow and ice,
Okay.
naturally occurring hazard, it was open and obvious, you could see the snow type things. Now it gets into a comparative fault situation from that. The law used to be what I thought was very odd and very it did not make any common sense to me, and it was if a parking lot has a bunch of snow on it and the owner of the property doesn't do anything, the hazard is as obvious to the customer as it is to the property owner. It's a naturally occurring hazard, so the owner has no liability for anybody that slips and falls in that parking lot. But if the owner of the parking lot attempts to clear that, and then somebody slips and falls on ice in the clear area, then there could be liability there. So it encouraged people not to clean, to clean their parking lots, which was weird. And they've gone away from that now, and it is, and a lot of things they tried to argue was open and obvious. If you had that step going into my bathroom. If someone wants to consider that a dangerous condition, I don't know if you would or not, but it's open and it's obvious. You open the door, you see it there from that standpoint. It's not hidden at all. And they tried to argue that on every type of thing the insurance companies did from there. And now they've changed it to where open and obvious is not an absolute defense. It used to be an absolute defense.
Wow.
If the court were to find it was open and obvious, there was no duty at that point, so there was no negligence. Now, that just is one thing the jury can consider in determining how much fault is on the defendant, how much fault is on the plaintiff in that setting. So when you look at an open and obvious, so if you've got snow and ice out in the parking lot and it just, it snowed overnight, it's obvious, well, the jury may look at it and say, yeah, the plaintiff is the majority at fault. If it's under a covered area to where, you wouldn't expect it to be, it shouldn't be there, and they haven't taken it, it's been there for overnight, it's been there for a long time, and they haven't taken any steps to correct it, then that's more of the property owner in that setting. So
That makes a lot of sense. And the snow and ice thing is a great example because I've always wondered, or a pothole maybe in the parking lot. I tripped on that and broke an ankle. I mean,
Yes.
well, you should have seen the pothole.
Correct.
You should have fixed the pothole. So
Correct.
It's chicken and egg kind of thing.
Exactly.
Interesting. Any other topics you want to cover related to premises liability? We've talked a lot about the commercial side of it, even got into common areas, which led us into the residential side, where we talked about stairwells, we talked about decks, deck railing, holes in the yard, things like that, all the way down to now coming back to the snow and ice, which could be on a residential driveway, walkway, or a commercial parking lot.
One thing that we probably need to make a little clear on this, that one difference, because I've talked a lot about motor vehicle collisions, and in that I talk about the PIP coverage, and your first $10,000 of medical is covered under PIP or no fault coverage by the vehicle on the vehicle that you were in at the time of the collision. So you have medical coverage to cover up to $10,000 of medical bills anyway. That's not the case in premises liability case. A lot of homeowners in premises liability policies will have some med pay coverage where they'll pay $5,000 worth of medical bills if you're injured on the property, regardless of who's negligent. Like if you're injured on my property, my coverage is that we'll pay a certain portion. You could be completely negligent, trip over your own shoelaces type negligence, and nothing to do with me. If it occurs on my property, my insurance is going to pay your medical bills up to a certain
Cheaper
dollar
not to
figure.
argue about it.
Yeah, instead of even if there's no liability on my part. A lot of homeowners policies have that in it. A lot of commercial policies have that in it. Some don't, but usually it's a very low amount. And $5,000 is about the most I ever see. There you see some that are $1,000 or $2,000, and that won't even cover the ER visit. $5,000 probably is not going to cover the ER visit from that standpoint. So you don't have as much medical coverage, or right off the bat in these type of claims. You may not have any medical coverage right off the bat in these types of claims other than your own personal health insurance. Now, the duty, the responsibility to reimburse your health insurance that I've talked about before in the subrogation aspect, if you settle with the property owner, then your insurance that may have paid some of your medical bills is going to be entitled to be reimbursed from that standpoint. The other side of that is there's not going to be any lost wage benefits until the case is resolved from that. The $10,000 of PIP can be used at least partially for lost wage benefits. If you're injured on the job in a workers' comp, you get paid lost wage benefits as well as the medical. In the premises liability, very limited medical and absolutely no wage loss benefits. I've never seen a commercial homeowners or commercial general liability policy that provided any lost wage coverage regardless of fault, which is what you see as the medical from that standpoint. I've said before, and I'll say again, have short-term disability insurance. You don't never want to use it, but if you need it, you're going to be very thankful that you have it. That's the way you're going to make, if you get injured in something like this, that's the way you're going to make sure your bills are paid and food's kept on the table.
No, that's terrific advice. And I know you've brought that up a number of times, and it's something I don't really think about, but that short-term insurance policy it can be a lifesaver.
It can be a lifesaver, and I don't sell insurance. I'm not making any money off that advice.
Right. You sue insurance companies.
I sue insurance companies, but I give that advice because I think that is very good insurance. In fact, I here in my office, I've got a policy that covers short-term disability for my staff because I want to make sure they have that if they get hurt somewhere besides here, that they've still got money coming in to cover their bills. So
outstanding. Jeff, if somebody's listening to this and they have some additional questions, or they want to schedule a meeting to, hey, can I come in and talk about hiring you to handle my case? What is the best way for them to get a hold of you?
Best way to get a hold of me is by phone. I've got two offices, one here in Murray, Kentucky, one in Hopkinsville, Kentucky. But I have one phone number that I use. From that, I have an 800 number if you want to do toll free if you're outside of the 270 area code. But the office number is 270-753-0053. And then the 800 number is 1-800-844-5108. And that number, if you call that number, you'll during normal business hours, unless we're tied up on all the other lines, you're going to reach a live person to talk with you. From that, if you've got any questions over these things, call in. If you've been injured in a premises liability situation, call and we'll get some information, see about setting you up an appointment. The consultations to come see me are, I'll give free initial consultations. I only get paid at the end. I work on a contingency fee basis on these claims, so I only get paid at the end when I put money in my client's pocket. And I said I had the office up in Hopkinsville. One of the mottos for my office, the motto for my office actually, is that we provide small town service and deliver big city results. We tried to live up to that motto in all the cases that we handle. That's one of the reasons I opened up that satellite office in Hopkinsville, was to provide better service to my clients up in that area.
Well, and the thing is, even though you've got two offices, in a premises liability case, you're not limited to Western Kentucky. In fact, you handle cases in all sorts of different cities all across the Commonwealth.
Correct. I'm licensed to handle cases in every circuit court in the Commonwealth of Kentucky. So I can handle a claim in any county, in any city in Kentucky, and have handled cases in multiple different jurisdictions. I haven't counted them all up, but I've handled cases from Paducah to Pikeville. In that regard. And so there are some counties I haven't had cases in, but I've handled cases in Western Kentucky, Eastern Kentucky, Southern Kentucky, and Northern Kentucky. So
outstanding. Jeff, it's always a pleasure to spend time with you. I appreciate all the prep work you did for the episode, and sitting down and really kind of breaking down, what are sometimes complex legal issues, and to make them just really understandable. I mean, I think that's one of the benefits of this podcast. You've done well over 100 episodes now, and you're really just kind of giving common sense. This is really what this means, so that it makes it much more approachable, much more understandable, and hopefully it leads to a couple of extra phone calls for you as well, just because people are like, hey, I like how you approach this. And I think if you go out and look at your Google reviews, I mean, you've got well over 50 Google reviews. If I look up Robert's Law Office in Murray, Kentucky, for a solo practitioner, that's a ton of 5-star reviews that you've got out there. But I think you earn it, one, because you're living up to that motto on a very consistent basis.
I appreciate you saying that. Yeah, if you go on the reviews, you'll see, I think I've got 69 5-star reviews for the Murray office. Hopkinsville, it hadn't been open that long, so it doesn't have as many 5-star reviews there. But if you'll see what the clients are, past clients are saying, you'll see that most of the vast majority of my past clients are very pleased with the services that we've provided and the results that we've achieved.
Outstanding. Once again, Jeff, thanks for your time. We'll be back in a couple of weeks.
Thank you.
Take care. Bye-bye. Thank you for listening to the Robert's Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Robert's Law Office, you'll find a history of small town service and big city results.